For all they are present in here today with us, my name is Paula Barros. I am an advisor here at the Young Members Group of the Charter Institution of Arbitrators in Brazil. And I today have the honor to be a moderator in this amazing panel with its two amazing professionals about intellectual property rights in international commercial arbitration. So we have the two of them are incredible professors. We have in here Karin. Now I'll give my little clue in here. Karin is an amazing arbitrator, mediator, and domain name panelist, and also professor at FACamp, the University of Campinas, both in the undergraduate and in the lato and stricto sensu postgraduate programs. She holds the title of fellow here in the Charter Institute of Arbitrators in the Brazil branch. And she's also the director of the Mediation Chamber of Dispute Resolution Center of the ABPI, also known as the Brazilian Association of Intellectual Property. She has amazing experience with intellectual property, and she has been working with commercial arbitration and intellectual property since 1996. And also today, Karin is located here in Brazil as me. I am also here located in Brazil. And we have the great honor today to be joined by Shraddha Pandit. So Shraddha is an assistant professor at, and I'm sorry for the pronunciation, but assistant professor at SVQM's Curate P. Mehta School of Law in the NMIMS University in Mumbai. She holds an LLM in criminal law and administration. She won accolades at the Dehradun Literature Festival and National Advocacy Workshop. She's a very active scholar with many publications, and as professor, her teaching spans diverse subjects including human rights, contractual law, and gender studies. So in here today, what we plan to do is both Karin and Shraddha will make a quick presentation about international intellectual property in commercial arbitration in an international perspective. Later on, I'll do a few questions, and at the end, we will open up for you to make some questions too for them. You can make questions in the chat, and at the end, we will address them. So right now, so then we will start with a little presentation by both of them. Karin, would you like to begin a quick presentation about intellectual property in international arbitration?
Sure, it will be a pleasure. First of all, thank you very much, Paula and CIArb Brazil branch and CIArb Young Members Group for the invitation. It's a pleasure to be here. It's a pleasure to be also with Shraddha Pandit, who I learned recently, and I'm impressed by her experience and also the exchanges we had previous to this meeting in order to share a little bit the themes of our presentations. So I'm very happy of being here and being able to grant you a very international perspective of the bridge that we make between these two words. I say a bridge between two words because arbitration is transversal, right? When it comes to conflict resolution, we are dealing with several material laws. And when it comes to intellectual property, we do not always have a very smooth integration because we are dealing with different principles, logic, and practices. At least in Brazil, we are investing a lot in educating IP professionals on international commercial arbitration, especially at the Brazilian Association for Intellectual Property, and also at other arbitration institutions like the CEBAR, the Brazilian Committee for Arbitration. We have study groups that also make this bridge between intellectual property and arbitration. I think one of the main difficulties we'll face is that intellectual properties are territorial rights. So when we are dealing with intellectual property, we are usually dealing with the domestic law of a given country. Globalization and international commerce, of course, brings the need for a certain harmonization between laws. So we have many international treaties in place. I think the most famous we have is the TRIPS, the Agreement on Trade-Related Aspects of Intellectual Property Rights, one of the three pillars of the World Trade Organization, together with GATT and GATS. But we still have some domestic issues or domestic aspects of IP law that certainly interfere in an international commercial arbitration and should be a matter of attention to the arbitrator and the practitioners. When we talk about an IP right, we can talk about a right that is granted by the state, by the sovereignty of the state. So this is typically industrial property rights, like, for example, a trademark and a patent and an industrial design. So you need the interference of the National Patent and Trademark Office in order to analyze inventiveness, originality, in case of patents, industrial applicability, so that the right is granted. And once the right is granted by this institution, you have a property right, which is opponable against third parties, but it has some singularities as to a property right because it's an immaterial property, right? So there are several exceptions to the intellectual property rights and industrial property rights provided by law. For example, for research and development, and some exceptions on patentability of human beings, for example, and so on. Another branch of intellectual property we could name as copyrights, which are rights that are not subject to a granting by the state, by a state authority. So the registration, when made by the party, is a mere declaratory registration, so that at the end of the day, who really recognizes the existence of an intellectual property right are courts, or maybe in this case, arbitrators. So we have this huge separation between declaratory rights and constitutive rights, right? So this is something that we have to take into consideration because it will affect, for example, what is subject to arbitration or not, or what can be subject to arbitration or not. So whenever we talk about intellectual property, we think about subjective arbitrability and objective arbitrability. What do I mean by subjective arbitrability? Are the parties who are submitting this matter, this conflict to arbitration, capable of being there, right? So, for example, the Patent and Trademark Office, is it subject to arbitration on a mandatory basis? If a party wants, for example, to discuss the validity of a patent right or the validity of a trademark right. In Brazil, certainly not. I don't know very much about other countries in the world. I'm very curious to learn about the experience from Shraddha. And another important issue is, for example, authors of counterfeited goods. I remember when I was at the very beginning of my career, I was in an international congress on intellectual property, and we had the global head for IP litigation from Canon lecturing in one panel, and then he said that the most of the cases inside the company was being decided by national courts and so on. So I raised my hand and I asked, why is that arbitration is not the most elected path? And he answered me, because most of our cases are counterfeited goods. So we are dealing with the black market. And how do you bring the counterfeiter to an arbitration? Because an arbitration is an agreement between the parties, right? The root of the arbitration per se is an agreement between the parties. So counterfeiting is not something that can be decided by international commercial arbitration. But the other great majority of the issues that we have involving intellectual property rights, and I would say 80% of that would be licensing when intellectual property circulates in the economy, or research and development agreements, joint development and initiatives. This can, and I recommend, should be solved by means of arbitration. We can step on later on advantages of using commercial arbitration in these cases. But coming back to our scheme and root, so we were talking about subjective arbitrability and objective arbitrability. So not adequate for involving the national authorities, not adequate for involving the counterfeiter of counterfeited goods. Objective arbitrability. Maybe arbitration is not the ideal place to discuss the existence and the validity of an intellectual property right per se. I know of jurisdictions where this is made and where the arbitral award is enforced, the sentence is enforced, like for example in Switzerland, right? The arbitrators send the arbitral award to the National Institute of Intellectual Property, and the National Institute would would accept what is decided by the arbitrators regarding the validity or not of this right. This is not the case in Brazil, for example. So this will certainly bring a lot of insecurity for the party seeking enforcement of this award internationally. Once I was discussing this issue in another international congress, and the reply I had from one professor from the US was that, well, although we cannot enforce vis-a-vis the patent and trademark offices or against any third parties, erga omnes, it's still a great advantage if I have this declaration of invalidity made between the parties. So an arbitral award that is enforceable between the parties and that can bring this safety or this assurance to one of the parties that this patent is not considered valid against this party, this is a great advantage. And I must agree. I mean, maybe you don't have the enforceability against third parties in all the jurisdictions where this arbitral award produces effect, but having this enforceability inter-party between the parties is already a great advantage that we have. Another issue regarding the object of the arbitration or of the dispute per se would be contractual clauses and violations. Then we have the best environment for discussion, a contractual breach, a contractual violation, can be very well object of an arbitration and can be decided by arbitrators on a very good basis. And this is very common, and this is the majority of the cases we have, for example, in our Center for the Resolution of Disputes of the Brazilian Association of Intellectual Property. The majority of the cases there are of franchise agreements. You can imagine that franchise structures brings lots of conflicts in terms of network and rights granted to one franchisee and to the other, and differences in treatment. So it's a very well divulgated practice to do this. And I think this is a good introduction. I would like to give the word to Shraddha and then to participate in the debates. Thank you very much.
Thank you, Karin, for your amazing introduction on IP rights, especially when it comes to dealing with differences when it comes of recognition of IP rights in different countries, and how this affect not only the arbitration, how to defend itself, but the executability of the arbitral award. It's a very interesting perspective. And Shraddha, would like to know also from you about international intellectual property rights and international commercial arbitration, about your practice, how this should develop in the real world, in the practice.
Yes, thank you very much, Miss Karin, and also Miss Paula. I have a little bit of a PPT slideshow. Can I share my screen?
Of course, it is up. Is it appearing for you, the button to share?
Yes, I'm trying to share. Is it visible?
Yes, it is already presenting to us. It is in presentation mode.
Okay, thank you. There's a little discussion that I have for today's lecture, and I have a short PPT for that. So I'll just go to the main topics. Yes, before that, I just have a small disclaimer. I've used certain images and names today for this lecture, and the copyright, of course, vests with the respective IP owners. So let's get started. Introduction. Today, I'm going to speak about a few topics such as IPR, trade secrets, and the importance of arbitration in trade secrets. So, first of all, I would like to have a little discussion about intellectual property rights. As my co panelist has already spoken about intellectual property rights, these rights are granted to individuals for their original creations, such as literary, musical, artistic, creative works. And it is something which we protect in India as well as in other countries, and all of the member nations of the UN, United Nations, are we have a mutual duty to protect the copyrights of our member nations, of our citizens. Article 27 of the UDHR also provides for the right to benefit from our own original creative works, and to protect the moral and material interests, also the commercial interests, to earn money out of it. And it is basically an intangible right. The importance of IPR can never be refused, can never be refuted. So we have the Paris Convention, the very first convention which speaks of in industrial property. Earlier, it was known as industrial property, and later on, we coined the term intellectual property. And as Karin also said, that some of the disputes are arbitrable. Some of the disputes can go for arbitration, the IPR disputes, and some of them go to the court. In India, also, some of them go to the court. So, what are the different types of IPR? We have copyright, trademark, patents, geographical indications, designs, trade secrets. So, I'm going to speak about trade secrets today. Confidential information, traditional knowledge, biotech, agri tech. So, a lot of things that can be protected under IPR. And yes, these are a few famous trademarks, and all of us know about them. Um McDonald's, Emirates, Tata, these are from India. Amul, Chanel, who doesn't know about Chanel? Amazon, Microsoft, um, Heinz, Royal Enfield. So there are lots of brand names which can be covered under trademark, which can be protected under trademark, and they are important as trademarks and service marks. So for goods or products, we have trademarks, and for services, we have service marks. So all of these are covered under intellectual property rights. Also, here some of the examples we have for the other types of intellectual property rights. For example, copyright. So anything which is written, which is an artistic work, a story, a sketch, a drawing, a photograph, it can be covered under copyright. It can be protected for the lifetime of the author or the creator, plus 60 years or 70 years as per the different jurisdictions. So there are a few stories or novels which have become world famous, and now we can adapt them into a television adaptation, into a film, or as um, a web series, OTT series, because the copyright has expired. For example, William Shakespeare's uh, drama theater, Othello, Macbeth. So he was a great playwright, and most of his plays are now open to adaptation, because um, now they are out into the public domain and the copyright term has expired. So all of these things are somehow important to us in everyday life, in our everyday work life, our personal life, in trade, in commerce. For example, here I have given a small image of a ship, a submarine vessel, if you can see down below. So there is, a drawing, a sketch, which can be, the specification for a patent. Later on, it can be patented. It's a very old picture, but that is how we have to give complete details, complete disclosure for a scientific patent. Also, we have the songs and the music, lyrics when it comes to copyright. So, who doesn't know about Taylor Swift? And also, there are Korean pop culture, Korean songs, and music. Also, where we have lots of people in India, we view Korean drama, and they are somehow, we can say, covered under copyright. Copyright is extremely important these days. Defining a trade secret. Coming to trade secret, which is another type of IPR, another kind of intellectual property right. A trade secret, as the term suggests, it's a secret. It is something which gives an edge or a competitive advantage over a competitor in the market, something that as a business owner, a person would not like to reveal, or instead would like to keep it as a secret, as a piece of confidential secret. So is covered under, we can say, intellectual property rights, but it is not supposed to be disclosed. Unlike a scientific patent where we have to give a complete disclosure, here we don't have to give a disclosure because it is meant to be kept as a secret. Examples could be formula, designs, processes, methods, customer lists. It could be recipes. It could be anything, in fact. So Coca Cola is the best example that can come to my mind right now, because Coca Cola is a trade secret. The secret formula for making Coca Cola is not known to anybody till date. Even the secret blend of spices that goes in KFC's fried chicken is also one of the classic examples. Another example could be manufacturing processes, software algorithms, research and development data, or client list, customer list, marketing plans, product designs, pricing list, engineering drawings. So, a lot of things that give us a competitive advantage in the marketplace, and which we would like to keep buried under the NDA, or in non disclosure agreements. We would not like them to come up to the surface. And that is how trade secrets are important to us. Importance of a trade secret protection regime. Coming to its importance, I would like to say that everything cannot be revealed out, otherwise businesses will not be successful, otherwise earning money or the commercial aspect of it will not be taken care of. And some of the things can be we can choose, some of the things we can go for patents, we can file a scientific patent and get it patented. Again, for a patent there is a term of 20 years, after which it might become public knowledge, it will come out into the public domain, it will become accessible to the people and will no longer remain a trade secret. But if there has to be a trade secret, something which gives us an edge and we would like to keep it undisclosed, then it can be protected under the concept of a trade secret or a confidential information in perpetuity. We can protect it for long. And how will we do that? By a contract known as an NDA, non disclosure agreement. And most of the agreements which we see today in today's times, currently in India and in other places, they are entered into by an employer and employee. So the employer or the company wants the employee to keep their mouth shut. They should not disclose important information, and it is extremely crucial that it is written down on paper. Some of the details might not even be recorded onto paper because they are so volatile, so sensitive, that they can't even be recorded in the NDA. But there can be a passing reference, and it is understood that it should not be leaked out by any means, oral, written, verbal, non-verbal, or even on the internet. It should not go to third parties, or it should not go out into the public domain. And that is how trade secrets have been are protected and have been the important backbone of businesses, I will say, till date. If a particular trade secret has to be leaked out, prior written permission has to be obtained, without which it is illegal to leak out or to reveal a trade secret. The owner of the trade secret has legal remedies. So there are lots of remedies. I will come to that a little later. And every business has some or the other secrets which need to be protected. So it can be client list, it can be user data, consumer information, consumer experience, email IDs, telephone numbers, uh, including videos, photographs. In case of a food business, it could mean the secret ingredient that is used in the recipe. As you can see in the PPT, I have given a few images. It could be the way a chef makes a particular master dish, and for which people come from far away places to just have that particular food dish or that particular recipe. It could be images, videos, PPTs, educational material, software, hardware, any kind of data which is very crucial and important for that particular business. It is increasingly at risk. Trade secrets are increasingly at risk of getting leaked now, because we have internet, we have lots of ways and means of leaking the data, and it can cause cross border disputes even. So it is important that we keep the secrecy intact. Even while we are into a dispute, we need to resolve the dispute very patiently and in a way that confidentiality will be maintained throughout. And that is the reason arbitration becomes important. Arbitration is one of the important choices, and a smart choice, I will say, would be out of court settlement and arbitration rather than going to the court, because in court we will have to give all the details, the nitty-gritties, the intricacies of the dispute, which will reveal our trade secret and everybody will come to know of it. It will come on record. Otherwise, there's no other option, because courts will want everything to be revealed. But in arbitration, we can maintain confidentiality. So, what is the legal framework in India and across the globe? So, I have chosen a few jurisdictions. In India, we do not have a single written law, codified law to protect trade secrets, but there are different provisions, scattered provisions. In criminal law, we have criminal breach of trust. In contract law, we have breach of contract. And in cyber law, we have again IT offenses, Information Technology Act. And we can also, complain under the regular criminal law. So if it's an employer employee agreement, most of the times we have a written NDA, a non disclosure agreement, and the employee can be sued for breach of contract. But we don't have a specific single law for it. Instead, we have different provisions. And if we contrast it, we compare it with the US, we have in the US, US Defend Trade Secrets Act, and there is a Uniform Trade Secrets Act, UTSA. So in US, they have a written law for trade secrets, which is piece of legislation that defines what could be trade secrets, how to claim the wrong that has been committed, and what are the potential remedies, injunctions, damages for the violation and infringement of trade secrets. Coming to the other jurisdictions, such as European Union, there is a specific directive, there's a specific law for the entire European Union, which is the EU Trade Secrets Directive. So all of the countries of the European Union member nations, automatically they come into this particular scope of the law. The law is applicable to them, and trade secret holders can file for illegal leaking of their documents of trade secrets, objects, videos, any kind of material, substances, electronic files, audio, visual images, anything that is leaked. They can ask for destroying that material, or even legal taking appropriate legal action against it. The only exception would be that trade secrets might be disclosed in good faith, where it is done in order to protect general public interest. There, the legal action might not be taken because it is an exception to the rule for the benefit of the people. Common disputes. What are the common disputes involving trade secrets? If trade secrets are leaked, there is a lot of chaos. It becomes a big problem because the entire business system fails. Competitors get a hang of whatever we do, and it can also lead to serious violations. Hence, it is important to have a strong NDA. But if an employee goes ahead and breaks the NDA, or there is a breach of the non disclosure agreement, then legal action will definitely get triggered. There can be misuse of the confidential information in R&D collaborations, in research and development projects, and that is how it creates a lot of hurdles in protecting trade secrets. So when there is a trade secret leak, you can either go to court, which is the traditional format or the traditional route to take legal action against the wrongdoer, or in today's times, you can go for arbitration, which would be much better. It is an out of court settlement, an amicable, friendly settlement of a dispute, and more or less flexible as to the rules of arbitration. Hence, it is better, in my opinion. Why is arbitration better? So I will now somehow vindicate my stance, my opinion. Private proceedings maintain secrecy. Why wash dirty linen in public? Why should we reveal the secrets in public? In court proceedings, we'll have to reveal everything, and there is no way to protect the secret. The secret will become an open secret or public knowledge. Specialized arbitrators, parties can choose expert handling, flexibility of procedure, which only arbitration will give them, and no other procedure can give them this kind of specialized handling. Enforcement of awards under New York Convention. Most of the countries of the world these days, including India and Brazil, follow the New York Convention route. So, what is the New York Convention route? We'll come to that. This is used to resolve international disputes involving IP and trade secret infringement by arbitration instead of going to the regular courts. Applicable laws. What are the different laws that are applicable? One of them is trips. I believe even Karin was speaking about trips, which is trade related aspects of intellectual property rights, which is one of the important agreements of the World Trade Organization, WTO, and most of the countries of the world are a member nation of the UN WTO, and automatically they are members of trips. So by which you have a specialized dispute resolution mechanism. You need not go to the court, you can instead go for alternative dispute resolution, ADR, and arbitration is one of the most important types of ADR. Then we have UN Citral model, United Nations Commission on International Trade Law, which facilitates international trade and investment. And it is an important body of the UN which encourages out of court settlement. Coming to the two important awards by which we bring in international arbitration. So if there is a party sitting in India and there is an agreement with another party, say suppose sitting in Brazil, and we have an agreement by which we are going to do a joint venture, a business, and there are some trade secrets that we need to protect, but one of the parties has somehow breached the contract, has leaked out the secrets. So, what can the other party do in this situation? The other party can enforce that particular agreement under international law, basically the New York Convention awards. And that particular agreement, if it has an arbitration clause, the dispute will be settled out of court by an arbitrator or an institutional arbitration. Instead of going to the court, we can resolve the dispute amicably and we will have a better solution with flexibility. So, this is possible only because both India and Brazil are a party to New York Convention. So, basically, we have two important conventions, and most of the countries of the world are a party to either of them. And because New York is the recent one, most of the countries are parties to the New York Convention. So, what is the New York Convention? It emphasizes upon enforcement of foreign arbitral awards by which, instead of going to a court for an international commercial dispute, it can be resolved commonly known as ADR by ADR, alternative dispute resolution, and we can go for an arbitration proceeding. We can select the seat of arbitration, the place of arbitration. We can even select the arbitrator. So, in a court, we cannot select the judge, but in arbitration, we can select who should be the arbitrator. Should it be three arbitrators or only one arbitrator? And that is how we get to choose, pick and choose. A lot of flexibility is given under the New York Convention award, and in fact it replaces the earlier much rigid Geneva Convention award. So that is how international law paves the way for arbitration. These days people would go for arbitration instead of a regular court dispute, as ADR makes things simpler, faster, practical. Challenges. What are the challenges? The need for disclosure in proceedings versus maintaining secrecy. So, some of the things we would have to unfortunately come up with, we'll have to disclose, and we cannot maintain 100% secrecy even in arbitration. Although the dispute is related to trade secret and we want to protect the secret, but we will have to also give details if we want to protect it. So, there could be leaks even from the witnesses or the expert witness, the expert people who come, and there might be some or the other things that go out of that particular room, which might cause even more damage. So, these are some of the hurdles or problems that we need to overcome. Also, there is this dilemma that a person might be in, whether I should go for patent protection, because patent is only limited for 20 years, but trade secrets are protected in perpetuity for lifetime. So should I keep it as a secret? And this leaves a lot of room for interpretation for choosing between whether I want it to get into the public hands after 20 years, or I want my secret, or my product, or my client list, or my technology to be kept as a secret forever. So that is how I would have to choose one of the routes, and that is a dilemma sometimes which we need to resolve. Procedural safeguards, we can have confidentiality, we can have in camera hearings whereby no third party can come into the proceeding. It can be behind closed doors, and it will be only for the parties who are actually directly involved in it. Witnesses will also have to keep their somehow mouths silent. They cannot leak anything outside of the arbitration proceeding, and that is how we can restrict the access to information and documents. Evidentiary considerations, again, we need technical experts, we need digital forensics, especially for electronic evidence. In today's times we have very high tech technology that is used, so we need technology experts, AI experts, experts in the field of information and communication technology, machine learning. So all of these people can be called as expert witnesses, and we can take their help. Role of arbitral institutions. What are the different institutions that provide institutionalized arbitration, and who also provide us the rules for settling the dispute out of court? So basically we have the International Court of Arbitration, ICC France. Sorry, ICC France has its own rules, and it can be applied for international commercial arbitration. Video conferencing these days is possible for hearing of parties, because people might be living in different countries, the parties to the dispute might be in different cities, so online proceedings are possible. Settlement agreement between parties can be drawn out into an arbitral award, so the terms and conditions can be decided by the parties themselves. It will be also given as an award by the arbitrator. Secondly, we have London Court of International Arbitration, very famous. So it is the oldest arbitral body in the world, dealing with international disputes, arbitration as well as mediation. It lays emphasis on strict rules on privacy of proceedings. So the most famous is the London Court of International Arbitration, London, and the second most famous these days is Singapore. Singapore International Arbitration Center in the Asia Pacific region. It is a not-for-profit international organization based in Singapore. It provides for arbitrations under its own set of rules and norms, and it also follows the UN Citral arbitration rules. It provides for speedy, that is expedited, speedy, fast procedures for urgent relief. Then we have WIPO, World Intellectual Property Organization, WIPO Geneva, for specialized IPR related disputes. Also, we have a few organs of the UN which take care of sports related disputes, sports law. And we have regional arbitration centers in Asia. For example, Hong Kong International Arbitration Center, New Delhi, Delhi Arbitration Center in India, Mumbai Center for International Arbitration. So I'm speaking from Mumbai, and we have our own MCIA in Mumbai. The Hong Kong Arbitration Center is also very famous. Just after London and Singapore, it is the place where people go the most for state of the art facilities. It has been ranked first worldwide for the location, value for money, specialized rules, IT services, and helpfulness of staff. So they also provide innovative arbitration practice, and it is one of the most resorted to place. Just after London and Singapore, the third most popular is Hong Kong. Mumbai Center for International Arbitration has been set up recently. It provides ease of doing business within India for our own jurisdiction, and it also invites foreign investors and companies. At present, we have around 18 members as arbitrators, as experts in Mumbai, and out of them, 9 are from other countries of the world. They are from foreign countries, and they help in settling the disputes in a cost effective manner with best professional advice and expert handling. So here is a difference between common law and civil law countries. One is a common law jurisdiction, if you can see, and another is a civil law. So India is a part of common law of UK, United Kingdom. So most of the countries of the world, which are Commonwealth countries, will follow the common law system. And some of the examples could be India, Sri Lanka, USA. And some of the civil law countries of the world, on the other hand, would be countries of European Union, and some of the countries of South America, of Far East Asia, and they will follow the civil law system. So in common law system, the role of arbitrator is just related to the dispute, very passive. The things, the rules, the flexibility of timings, place, the seat of arbitration, and if they want to draw out a settlement agreement. So they have a lot of control. Whereas in civil law countries, parties have very less control, and the arbitrator has more control. He or she is an active investigator, and there are lower costs and faster proceedings as compared to common law. In civil law countries, there are few other advantages which are not there in the common law system. So that is how arbitration has some of the problems but lots of advantages as compared to the regular courts. And we can just see this flow chart, which says it leads to lot of discoveries and faster, we can say, expeditious, fast, speedy procedure, and expert handling, which might not be there in the regular courts. Interim measures, yes, in we can get the assets uh, freezing, evidence preservation, calling of the witnesses, and injunctions. So interim or ad interim immediate reliefs can also be given to expedite the process and to protect the trade secrets for urgent protection. Enforcement rules, of course, we have to follow the New York Convention Awards, because that's the most resorted to in current times. National courts may also help in case some of the orders an arbitrator cannot provide. We can definitely go to the regional courts or the national courts, and they can help us in some of the orders which are given only by the courts, and they have more authority in that case. Confidentiality needs to be maintained, but it varies as per the jurisdiction. As I mentioned, in common law countries, it might be a little different. In civil law countries, we have a different set of rules. So, again, we need to maintain that as per the country in which we live and as per the parties to the country they belong to. There are recent case examples like WIPO arbitration between pharma companies over formula misuse, ICC case involving ex-employees' use of proprietary designs, and lessons tailored confidentiality orders are essential. So, what are the lessons that we have learned? Confidentiality is supreme, privacy is supreme when it comes to protection of trade secrets. Best practices: clearly define your trade secrets, make a robust, very strong, strict NDA before sharing of any information and entrusting your information to your employees or to your colleagues or to third parties. It is important that we have a strict arbitration clause, and the NDA puts down everything in black and white into writing so that we need not have a leak. But in case there is a leak in the future, we should be prepared to resolve it. The dispute resolution clause is important. And if there is a clause for arbitration, definitely we'll go to arbitration first and not to the court. And automatically things will get triggered from there. plan for secure handling of digital evidence. In today's times with increasing technology, we are also at a risk of lot of other things, of cyber crime, of leak of data, and invasion of privacy. So we need to be protected against these, and we need to have good handling of our digital devices. On a closing note, I would like to share some latest statistics. So, regionally, even in the Middle East, in Saudi Arabia, Qatar, and UAE, um, there has been a surge and increase in arbitration, and disputes are settled by arbitration post FIFA World Cup, and new vision and legal reforms. Currently, all the countries of the world, we are trying to achieve UN SDGs, United Nations Sustainable Development Goals, by the year 2030. And that is the reason we want to settle the disputes in a speedy manner, increase efficiency, and bring about peace and justice and increase trade and commerce. Hence, ADR or arbitration goes hand in hand with this vision 2030. And most of the countries, like even South Africa and member nations of the BRICS, so India, Brazil, China, South Africa, all of us, Russia, we are in the BRICS. So we are also encouraging ADR, we are encouraging out of court settlement. Asia Pacific, yes, Singapore, Hong Kong, in Europe, France, Germany, London, all of these countries are trying to bring in arbitration. If you can see the graph, a line graph on the right hand side, London Maritime Arbitrators Association, Singapore International Arbitration Center, and International Chamber of Commerce, they have seen a surge, an increase in the arbitration proceedings in the last few years, right from 2016 till last year 2024. We have the statistics over here, and number of cases have increased. So people are showing faith and trust in arbitration. So that is how we go forward. um, on a concluding note, arbitration offers strong protection for trade secrets if it is well managed. It balances transparency and confidentiality, which is very important. Careful procedural planning ensures fairness and secrecy. I would also take this opportunity, and I would like to thank all my viewers, all my students, and all the participants today to hear me out and to help me deliver this lecture. I would express my gratitude to my co-panelist, Miss Karin, for her wonderful introductory session, which helped me to also join in the discussion a little later. Also, Mr. Bruno, who invited me for this event today, and our moderator, Miss Paula, uh, for her entire effort of putting things together and helping us throughout, and the entire organizing team, and Carolina and other people. Thank you so much. The Chartered Institute of Arbitrators, Brazil branch, and all my students who push me to excellence, and of course, my mother, who helps me every time, a constant moral support and pillar of strength, who pushes me to do something better each day. And thank you, everybody. With this,
Thank you so much, Shraddha, for all your presentation. It was indeed it really did painted a picture of what IP is nowadays inside this umbrella, especially what norms apply both in India and internationally, the main issues that may be faced, and pros and cons of arbitration, and maybe best practice, what to do to better deal with cases regarding trade secrets and also intellectual property rights as a whole. We are a little bit late in our schedule because of the time that we started. So I do know you both have very busy agendas. So I would like to just make a closing question for you both to, as we have very young practitioners in here, they are very eager to not only learn more about international property intellectual property and also interest in getting involved in commercial arbitration, international commercial arbitration. I'd like to hear from you both. What would you suggest for young practitioners so that they can get in touch with both IP right cases but also international arbitration?
Well, I raised my hand. I wanted to compliment on Shraddha's lecture to make like a link of both, and also for the Brazilian participants. So maybe
Saw this, please.
no. I would like to remember that trade secret is not an intellectual property right. In Brazil, it's ruled through unfair competition that goes a little bit far beyond this breach of contract or other civil law issues that Shraddha brought, because we have a list that's non-exhaustive of acts that constitute unfair competition. So although it's ruled under industrial property law, we have an indirect protection in case it's unlawfully or fraudulently disclosed, and indirect as well through the agreements, which Shraddha really excellently brought here, NDAs or confidential clauses in agreements. So whenever you deal with an information that classifies under this Article 39 of TRIPS, and I think it's Paramount 39 of TRIPS, you can take all the measures that are necessary to protect it. But remember, the great difference with another intellectual property right is that you don't have an exclusive right on the information per se. You create this exclusivity through this confidentiality agreements. That means it may be a very strong protection in the sense that it's enforced for an eternity, but it has really a weak side, which is once it is disclosed, you have a course of action against who unlawfully disclosed it, but not against all third parties and the public who now has access to it. So this is paramount when deciding how to protect your technology or substantial information. And for example, reverse engineering is widely acceptable. If you had access to the product that contains a trade secret in a lawful way, and from this you make a reverse engineering, for example, you take a Coca-Cola and you put inside a machine that can see the ingredients and the percentages and so on, and produces another soda drink, you have been lawfully dealing with this. So this is mainly some basics of trade secrets that we have to be careful when qualified under intellectual property. And I fully agree with Shraddha that arbitration, international arbitration, is a great space for dealing with trade secret violations, because usually you're dealing with an agreement between parties, right? So it's either an employee or a supplier or someone that jointly developed the secret with you, the technology with you. So you have the basis to insert an arbitration clause. So this is very nice. And something that Shraddha brought that is very important whenever we deal with intellectual property, also including trade secrets, interim measures are of utmost importance. So, for example, when you go to specialized courts like the WIPO Arbitration Center, or in Brazil, the ABPI Arbitration Center, we have very strong rules as to interim measures and injunctive reliefs, because when you have the decision in 2 years, in 1 year, maybe it's too late, right? So whenever you're dealing with intellectual property, this is very important. Thinking about your question specific, Paula, what to suggest to students and young practitioners, I would suggest that you join the associations, right? We have CIArb that has many learning tools and forms and courses and this kind of marketing and webinars for you to improve. But maybe specifically relating to IP, maybe join intellectual property associations. In Brazil, we have the ABPI that usually organizes international congresses. There's also LES, Licensing Executive Society, which is very active worldwide with lots of certifications and courses. I enjoy it very much. Privacy, you have the IAPP. So go after the associations for more practice-oriented studies, maybe not so theoretical. And one exceptional tool for practitioners, and I think Paula and Shraddha will also agree, are the moods, right? So there are many competitions that are organized by different forums, and the Brazilian Association on Intellectual Property has also a mood involving IP. And this year's case involves games. So it's very interesting, but whenever mood you take part, you learn a lot. So thank you. That's what I wanted to say.
Shraddha, the floor is yours. You can compliment on what Karin have talked about trade secrets, and also we would love to hear from you how young practitioners could get in touch not only with international commercial arbitration but also with intellectual property right cases.
Yes, so I completely agree with Ms. Karin that moot courts and lots of activities which give practical knowledge and practical exposure to young advocates and law students would definitely help them in their career. And in India, we have every law school, every law college, university has an annual competition when we have the law students mooting against each other like a moot court. At the same time, we have a mock arbitration. So there, students get to know the nitty gritties, the procedure, the intricacies of arbitration, and at the same time we encourage them to participate in international competitions such as the Viz Moot, the Vienna Moot. So last year a few students from our university went to Vienna with a few professors. So that is how they get some idea of the actual kind of arbitration. And also if they start internships with lawyers and arbitrators, they can get to know what kind of disputes are arbitrable and which are not arbitrable, which need to still go to the courts. That is how they get the practical experience. And also at the same time, I was a part of WIPO summer school, World Intellectual Property Organization summer school. So when I was a student a few years back, so that time they had during the WIPO summer school a negotiation exercise. They had an arbitration exercise, a negotiation exercise, like a moot court, like a mock practice session. So whereby we were giving certain IPR disputes, and we were asked to see whether they can be negotiated and they can be solved outside of court, and whether we can go for arbitration. And some of them we went for arbitration. It was a nice experience, and every person was from a different country. We had different teams, and the knowledge and the experience that we gathered and the memories that we made are still come back to mind in a very fresh manner, and that is how we learn from each other different perspectives, how to negotiate, how to come to a balance, and how to compromise and uh, enter into a settlement agreement. In India, we are also now pushing for mediation. So, two things we are encouraging. One is arbitration, whereby there will be a formal arbitrator and institutionalized arbitration. Another thing we have recently introduced a new legislation, a new written law for mediation. So, we are also encouraging mediation and negotiation. So, most of the ADR mechanisms we have implemented successfully. So that is also how we are going forward. And it is a vast area for new young practitioners to have various careers. Career options are numerous, and it's an ocean of opportunities. With that, I would like to conclude. Thank you.
Yeah, it is great that nowadays, as you said, there is an ocean of opportunities. Not only we have nowadays these incredible courses like the WIPO summer course, but also these competitions that happen. In Brazil, we don't have this. Our universities do not have this organization to make competitions inside for students, which is a shame because indeed it is. It brings so much experience for the students and so much knowledge for them, not only about the things that they're studying, the law itself, but and the practice, but also how they can, as lawyers, how can they pour themselves inside during an audition? How can they actually act as a lawyer? Thank you so much for both for your insights on how they can try to get in touch with arbitration and intellectual property rights. We are close to the end of what we were expecting to end today events, but I do like to hear from you because I don't want to, make you have worries with your agenda. Do you want to continue and go to a Q&A, or do you believe that we should stop right now? What would you prefer?
I can continue a little bit, maybe 15 more minutes, and to just check the questions people have, if they have.
Yes, even I would like to take a couple of questions if anybody has any questions.
Okay, so for all here presented today, you can make questions for us. There is the Q&A button. You can type there any questions. I do not know if you have access to chat, but if you do, you can make questions over there right now. So right now, write down if you have any questions that after all the exposition we have today would like to make. Not only about, it can be both about international arbitration, intellectual property rights, trade secrets, but it also can be about, how to get in touch with the field, how to get involved and actually be a person that works with it.
Paula, you had thought about some questions that you had.
I had
The
previously.
moderator, you can go on if you would like.
Oh, well, as we have 15 more minutes. Let me see here. I do have a question for you, Karin, after what you said, actually, because you did said about issues when it comes to enforceability of the arbitral award in some specific cases, but that even with there is issues with enforceability, parties that can enforce it in between themselves. How exactly would that work?
Well, for example, if we have an arbitration award that considers that Part B did really perform a breach of contract, so it's due indemnification, and there is a contractual clause establishing a fine, so you have the fine. The arbitral award grants all this, but it also comes to another conclusion regarding a second patent that was licensed under the agreement, and says that this patent was not violated because it actually is unconstitutional, because there's no novelty involved in this technical knowledge, as per proof brought by party A regarding prior art that was identified in the database of several patent offices around the world, for example. So when enforcing the award inside the Brazilian territory, imagining this award was rendered not in Brazil, according to Brazilian law, if the award is not rendered inside the Brazilian territory, then you have a foreign award, you have to go through our Superior Court of Justice for enforceability if this is not spontaneously how do I say, applied by the parties. I don't understand it will be possible for party B against in favor of whom this nullity of patent 2 has been declared, to go to the Brazilian Patent and Trademark Office or for the Brazilian court to notify the Brazilian Patent and Trademark Office with an instruction to turn this patent invalid. This will never happen in Brazil. I understand this happens in Switzerland, for example. But indeed, nevertheless, Part B will still receive damage compensation if she's able to execute and get the damages, and it will be able to use in a free way the technical knowledge object of this patent inside the Brazilian territory, because you have an arbitral award that has been enforced and that recognizes that the patent is null and void against in the relationship between company A and B. So maybe company C would very much like to use this technical knowledge, but will not be possible because the patent is still valid. But company B, who has the arbitral award, can use it freely. So this is a huge competitive advantage. And she has paid for it, right? Paying for the arbitration. So this is more or less the rationale behind it. Yes.
Yeah, these are very interesting. I was willing to understand better how exactly would this work. And also I would like to make a question for you, Shraddha. When we were talking about trade secrets being leaked, it did raise me a question about how to bring this to arbitration. And you did say that in some cases there is an NDA signed by both parties. And probably in this NDA there is an arbitration clause. But if that's not the case, how can you bring the situation for before an arbitral tribunal to render a solution?
Yes. So, in the case there has been a dispute arises. So, for there to be a dispute, there has to be a leak of the trade secret or an alleged leak of a trade secret. So, one of the parties who feels wronged or their secret has been leaked will have to institute or set the law into motion. So they'll ideally, first of all, they'll not directly start the arbitration, but send a notice to the other party and try to solve that issue at the threshold and get evidence of the leak first of all. And if it is prima facie evident that there has been a leak, then definitely according to the uh, arbitration clause and the seat that they have already mentioned in the arbitration clause, whereas they will follow the ICA or the International Court of Arbitration, International Chamber of Commerce, or they will go for the local domestic level arbitration, what kind of rules they want to resort to. If they have mentioned this, or there's it's mentioned in the agreement, then they will definitely go as per the rules, and they'll start with the procedure. So many a times people do not mention everything in the arbitration clause. They do not mention the number of the arbitrators, and they just mention that an arbitrator will be appointed. So then they have a little bit of flexibility whether they want to go for uh, in an odd number. We have arbitrators, 1, 3, 5, 7, or there can be an institutionalized arbitration. So accordingly, then they can go ahead with that. So ideally, it will depend upon the jurisdiction that they have selected. So, for example, in India, we have our own national law for settlement of dispute, Arbitration and Conciliation Act, and it also gives enforcement to New York Convention awards and Geneva Convention awards and UN Citral and other norms of UN. So it incorporates all of that, and it gives its own procedure as well. So accordingly, we can decide depending upon, like for example, recently I was reading about some of the countries of European Union. They have their own local law of France, of Germany, of Portugal, plus they have the EU law, and they also, some of the countries are member nations of New York Convention. So then they have a two-layer, a three-layer, three-tier system whereby they can either go for the domestic level arbitration, or in the case of international disputes, they can select between EU region, because they have their own laws for EU GDPR and privacy, confidentiality, data protection, or they want to go directly for the global law, whereby New York Convention, Geneva Convention awards, UN Citral model can be applied. But in any case, in case of a dispute which is of a global nature, and the parties are residing, say, suppose in US and China, or US and France or Germany or Portugal, then definitely they'll stick to the global law, which will cover most of the laws, and in an incorporated, cohesive manner. In most of the issues, New York Convention awards and that New York route will help them to resolve the dispute. So even if it's a trade secret related arbitration, it will require expert handling, because especially in today's times with emerging startups and software companies developing different types of codes, apps, and software, and their structure or skeleton of a software gets leaked out, and some other company picks it up and launches it into the market, and such kind of disputes are on the rise, especially in India and in Asia, Japan, South Korea. So this is something which is people are worried about, because technology is changing every day, and keeping some things of technology business in as a trade secret is very tough, because something always leaks out. Technology is something, keeping away all the traditional things, technology is something which is swiftly changing, and keeping a trade secret in such a business, in a startup economy, in a startup business, it's very tough. And currently most of the companies are tackling to uh, tackling with these technology transfer and R&D collaboration kind of projects, and trying to keep trade secrets, but many a times these secrets are leaked. So that is one of the recent trends that we can see.
Yeah, and it is very involved, the discussion about how to do with this information. Trade secrets is especially because when it comes to it, it can indeed make it an advantage for business or not, or harm their business if their trade secrets is exposed. And in times like this, it's difficult because oftentimes they do trust in some companies to hold their secrets for them. For instance, they use an app to make internal communications, and information can go out and can often become more worries for the company. It's very interesting it is interesting how things internationally, when it comes to intellectual rights, they look like, but there is some intricacies inside each of them. Like, for instance, what you said about especially the UN, they have a very interesting format that they deal with issues inside of them when it comes to intellectual rights and trade secrets. Is there anything that you would like to tell about us when it comes to like interests? Because we're talking about really enough in a general way, a very like academic way what it is. In practice, both of you, what kind of interests normally you see bringing cases of both intellectual property rights and trade secrets through arbitration? Karin did mention that she does see a lot of franchises cases, like franchisees and franchises bringing disputes to arbitration. But what kind of interests usually do you see? Like do you see a lot of the pharmacists, especially Shraddha in India? What kind of interests normally go to arbitration to solve this kind of disputes?
I just want to make an observation. There was a question for us, and I put this here in the chat.
Oh,
But
thank you. I didn't
but Shraddha can go on. Shraddha, answer Paula's question, and then we can go to the other question.
Yes, let's go to this question in the chat.
Yes. So, first of all, yeah, Paula's question, yes. What we can see recently is there has been an increase in number of cases going for arbitration are from startups, because currently we are encouraging startup culture. Startup is small businesses, and most of them are the first generation businesses. They are not very big huge group of companies or conglomerates. They are the very first generation businesses, group of friends who start their own business, and most of them come from uh, you know um, certain belts in India which are known as cyber belts, or most of the software companies are located there. So they have disputes related to the software that they make, the coding, the script. So the unique part in here in India is the software that we make is copyrighted. It is protected under copyright as a script, as a language. So the coding that is done, it's seen as a script, whereas in the US it is patented. So every jurisdiction has a every country, every culture, common law, civil law, everything has a difference. So in India we have the copyright, which is sorry, the script coding, which is done by software engineers. It is copyrighted, and many a times it is seen that a person who makes an app, who develops a particular software, he feels that, okay, even before I launch this into the market, or I go for a expo, trade expo, or I pitch this idea for funding, somebody else has already gone for filing a copyright application, or somebody else has already used this, and how come this is my own original work? And maybe one of his employees, or an intern, or a person who has just been hired for a few days, leaks it out, and then comes the concept of leakage of trade secrets. So somebody from his team, ideally his or her team, has somehow got an access to some restricted information or a particular file, and that has been communicated to a third party. That is how the entire story of, or we can say the entire conflict starts. So most of the sectors, if you're asking, most of the sectors we see in current days are coming from software and engineering related sectors, manufacturing sectors,
Yeah, there might be pharma companies also, but currently, if you see the last few years, last 5 years at least, half a decade, we are encouraging MSMEs, and that is micro, small, and medium enterprises, different kinds of businesses which are run by new generation, young generation owners, and lots of technology based, app based, application based businesses. So they feel that it's a very tough competitive market out there, and trade secret protection is more important, more relevant than any time before. So that would be my answer to your question. Another thing, yes, yeah, there's a question in the chat. So there is a subject known as private international law. We teach this subject to our students. It's an optional subject, so in our university. So basically it would depend on what kind of which law we want to choose, or which jurisdiction we wish to choose. So in one country, maybe breach of trust or breach of contract would be a civil wrong. In another country, it would be a criminal breach of trust, and it would be a criminal wrong. And then we have to decide, depending upon from where are the two parties, which are the countries, what are the laws applicable, and if there is a conflict of the laws, which law we have to select. So that falls under private international law, and we have to see the circumstances in which that particular breach or wrong has happened, and we can choose the law which will be applicable as per the civil law or criminal law, where the wrong actually happened, or where the cause of action has arisen. In today's times, it is very difficult to determine if it has happened in the internet or cyberspace. To be more precise, the jurisdiction will again differ, because a person sitting in some other country using an IP address or a virtual private network of some other place can do some wrong over the internet, and some trade secret of another person sitting in another country gets leaked out. So this is a very difficult, we can say, time and space, whereby it could be of because of a human error, it could be of a mechanical, or an error because of technology, or even because of AI. So now we are in the age of AI, artificial intelligence, which is again an emerging issue. There's a separate debate about AI and copyright, AI and trademark, whether AI can own a particular thing or not, or only human beings can own. So yes, that would fall under the premise of conflict of laws, or private international law. We'll have to select the jurisdiction, whether it should be a civil or a criminal wrong would depend upon the jurisdiction and upon the circumstances in which that wrong has been committed. Yes, I give it over to Karin to continue.
Yes, concerning the question, I will repeat because I don't know if everybody has access to the question. If the breach of trade secrets occurs between two parties in two different countries with vastly differing jurisdictions and legal approaches to the issue being arbitrated, how is that conflict resolved? For example, if a breach was criminal in one territory but civil in another. Thank you. Another question. Then what might happen if a technical error causes a data breach? Where does the liability lie if a company's internal network glitches, for example? So my approach to the first question, if you're talking about arbitration, then we have to see the origin of the jurisdiction of the arbitration. Is there an arbitral clause in the agreement between these two parties? Or once the violation has occurred, the breach of the trade secret, has the parties executed an agreement on arbitration to arbitrate? Usually, this is a great advantage of arbitration. The parties can choose the law that will apply it to the issue, the arbitrators that will decide on the issue, and the place where the award will be rendered. And then, of course, you have as a lawyer to make this jigsaw rational and thinking to see where would be the best place or the best material law to apply if I am the owner of the trade secret, of if I am using the trade secret, how is this law, how is the other law. These are all issues that are taken into consideration when deciding on the dispute resolution. So this is not a midnight clause anymore in the agreements, like they use it to say, but this is a very relevant clause. So maybe you were able to choose a material law that has a good coverage of the technical issues and of the trade secret that you have, but sincerely nowadays with the TRIPS, Article 39, and so on, most of the jurisdictions will protect you if there was a breach of the agreement or something like that. And regarding criminal law and civil law, criminal issues are not arbitrable, I think, worldwide, right? I don't know if this is changing, but as far as I know. But the interesting thing about the trade secret violation is that whenever you have a criminal violation, you also have a civil violation, because the civil is broader than the criminal. So there will always be a breach of contract or an unfair competition practice, and then this could be arbitrated. And then if you want to go against the criminal law remedies, then you would have to file a lawsuit in the court of the country in order to have these consequences. Usually due to the level of seriousness, nobody goes to jail because of a violation of a trade secret, but there are other very uninteresting penalties that usually the natural persons that run the enterprise who are affected by criminal law don't want to have. So this criminal law procedure is usually something that is chosen really to scare the actors of the violation and go after them. Thinking about the second question, so we'll answer first and then I'll give to Shraddha. What might happen if a technical error causes a data breach? Where does the liability lie? So, if there is a technical error causes a data breach, so we need to have more information on this hypothetical case, right? This technical error was in a software or a software application of one company that licensed the software application to a second company, for example, a financial institution. Can you imagine if a technical error happens in an application used by a financial institution, what happens? Well, data breaches, the legislation varies around the world. Pretty much we have the GDPR, the General Data Protection Directive from the European Union as a paramount or as a model that most companies use to develop their own national laws. I think when we talk about a data breach, we have several layers of liability being involved. So the first one is one company against the other. This can be object of arbitration for sure. And there must be an arbitral clause in the agreement between the app provider and the financial institution, for example. So the damages, the amount of damages, and the exclusion of liability, if any, agreed in the contract, all of this will be object of decision by the arbitrators. In Brazil, there is a tentative of doing a mediation between data subjects that were impacted by a data breach and the company that did this perform this data breach. So this is very interesting. This platform does not provide for arbitration yet. And then you have also the consequences of this data breach between the company and the National Authority on Data Protection. And this is an administrative issue, and maybe a fine will be applied to the Brazilian company on an administrative level. This is also not subject to arbitration. But all the rest, inclusive this regress from the company that had to pay something to a data subject or to the national authority against the other company that caused the data breach. This is possible to be arbitrated. I'm laughing because the questions, they can always be so complicated. So the replies will be as complicated as the question, right? As a professor, Shraddha must know this.
Yes, and the good thing is that is an exercise for us to try to, think about answers for it. I don't know about you, but I think it's fun to try to do these exercises of intellectual exercises.
That's the
Shraddha, when it
spirit
comes,
of the moods, right? The cases under
believe
the
so.
moods are usually unsolvable. So
Yeah, and
Yes,
it's sometimes it actually gives us a lot of food for thought. So good exercise for the brain. Yes.
exactly. Keeping us sharp and make sure we go. When you come of old age, we still have everything working really well open here. So, Shraddha, when it comes to the second question, what do you think about what would happen in a certain data breach? Like Karin said, maybe a company that had a third party that would organize this data, but ended up breaching it.
Yes, so there could be two things that could be done. One is, as Ms. Karin has also explained, if there are two companies and one company has somehow licensed their technology to another company to use it, say suppose there's an airline and they have their customers lists, email ids, contact numbers, payment details, and they have given another company the task of processing this data, and they have somehow licensed the technology to another company just to process the data, and the glitch has happened with this other company. Okay, so then it could be arbitrable between these two. But as to any third parties who want to sue them for damages or for negligence or negligent handling of data or leakage of data, or privacy issues, it would not be arbitrable. It would go to a regular court, for example the civil court for law of torts, or for negligence or damages compensation, or even in today's times we have cyber laws, and we have in India we have IT Act, Information and Technology Act, which covers different kinds of cyber crimes, and we have a new law on similar lines with EU GDPR. We have made our own law for data protection and privacy, personal data protection and privacy. So any third party who feels that my data has been leaked, they can sue both of these companies, and it would not be arbitrable. But it would be arbitrable as to the extent if there's a relationship between these two companies and there's an existence of a contract with an arbitration clause. So only to that extent it can be arbitrable. But most of the area which goes for data protection, privacy, handling of the information which is highly sensitive, confidential, and there has been a leak, then it would also go under cyber crime and information technology law. Because once people give their sensitive data and they entrust the data with a particular person who is handling the data, whether it's a company or it's a private person or an institution, for example, an airline or a hospital or a hotel, and there has been a serious data leak, then it is the liability to compensate for the loss and also to own up the situation. So it will not just go for arbitration. Arbitration, yes, some part of it would be which would be borne out of the contract, but the rest of the part would be like a public liability or a responsibility towards the public for mishandling their data. It would be a part of the civil law and the cyber law. And if there is any severe fraud or misappropriation of money or any other thing with that, it would also go for the criminal law as per the facts of that particular case. But currently, looking at the norms of data protection and privacy worldwide, whether it is EU GDPR or if it's the data law in the data protection law in the US or in Singapore, data privacy has become very important. And any kind of a data which is not encrypted or not protected enough and it gets leaked out into the public, it can attract severe penalties. So it would not go for arbitration, it would go to the regular courts where people ask for certain kind of an accountability or transparency, and certain kind of liability would be levied upon the wrongdoers, and they would not be able to just settle it out of court like a civil matter. It would go to the court, and they would also have to give a public apology, and somehow they are responsible for handling data. For example, if it's a hospital and it leaks out the data of its it is not a deliberate or intentional leak, but unfortunately, unintentionally also, if the data gets leaked, it would harm the patients, their families, it would cause a mental trauma, and it would not be arbitrable. It would go for damages and severe penalties.
Yes, it's very interesting how like individuals, it's sadly that individuals can go to arbitration, but it's interesting that they can go to courts to, if the data was leaked by companies, to be compensated in somehow. At least in India, this works in some other countries. I do not know if in Brazil we can do that. Karin, do you know if in Brazil we can do something like this? Similar?
Sorry, what I didn't understand what you were asking exactly. Going after
Because the Shraddha bring out that a party that had their data leaked because a company had a data about them, but another company that was responsible for keeping this data let it leak. So the person that this data was leaked about, they cannot go to arbitration as Shraddha brought out, but at least in India and some other countries, you can go to courts to ask for damages and also other protections. So do we have something similar in Brazil? Because I don't remember having something like this in Brazil.
Yes, our LGPD, our data protection law, rules the data subject access rights to the data, and rules also fines and the relationship between the companies and the data processing agents and our national authority, which is ANPD. But we have, I think, since 2 years, the recognition of the data protection as a fundamental right in the Constitution. There was an amendment to our Constitution. So based on the Constitution and on the Civil Code, any data subject can file a lawsuit for the breach of its data, not only privacy and more generic, because we used to do a very long construction to come to the data protection itself. Now we have a fundamental right on data protection. So damages and so on can be requested on a civil lawsuit. Criminal law, there's still lots of discussion in Brazil because the typicity needs to be very strict for something to be considered a crime. But we have many law initiatives on cyber crimes and so on, and very valid constructions being done by some doctrine and scholars in the sense that it's also possible to do this from a criminal perspective. But civil perspective, for sure, it's only a different course of action and it's non-arbitrable. But as I was saying, there is a platform from the government trying to, and this is the consumidor.br, the same platform that is used for consumers, trying to do the mediation of this kind of breach between the citizens and the companies. So mediation is already there, and they have a platform for that, for data breaches, but arbitration, not. Although some consumer rights can be subject to arbitration under our Brazilian arbitration law, right? So let's wait and see the developments. It's all very new.
Yes, it is interesting how the discussions are developing, not only in Brazil, but also to know about India, how things are going in other countries, how the discussions are going, and ways that countries are going to try to protect people's rights when it comes to their own data. And also, not only the data, but also, as we were speaking before, about their intellectual properties and the trade secrets in a time like this, where information can go out into and get in the hands of many people in seconds, now that we have social media and internet as it is nowadays, accessible to so many people. So I do believe that we should come to an end today. I do not want to take more of your very precious time. And I would like to thank you so much for being here today, talking with us and talking to the students about intellectual property and international commercial arbitration, giving insights about not an academic insights, but also practical insights to them about the whole field. Would you like to say something, final remarks?
I would like to thank you. It was a pleasure to be here. Thank you, CIArb Brazil Branch. Thank you, Young Members Group. Thank you, Paula. Thank you, Bruno. Thank you, Shraddha, for the very lively and interesting exchange of knowledge. And thank you for the questions there as well.
I would also take this opportunity and thank CIArb Brazil branch, Ms. Paula, Ms. Karin, Ms. Carolina, Mr. Bruno, and all the attendees, and also those who would attend on YouTube when this recording will go there. So, thank you, everybody. And it was a wonderful experience. It was an enriching experience. And I hope this knowledge sharing will also continue in the future with some other conferences, discussions, debates. I would love to be a part of. Thank you very much.
Sure, we're open for future collaborations again to happen in the future. So again, thank you so much.